here is through the sense of smell. So although the commission of the crime was not within his view, because it was hidden inside the body bag, neither was it within his sense of hearing. But because it is within his sense of smell, and he, being trained on that line, dealing with narcotics, he is regarded as an expert on perceiving whether the particular belonging inside the body bag is dangerous drugs or not. And even before the same was intercepted at the checkpoint along Cannon Road, the anti-narcotic agent already concluded that there is this contraband on board the passenger bus consisting of dried marijuana leaves. So this is brought about by his perception of smell. Ultimately, therefore, the word presence in the first situation that would warrant an arrest without a warrant of arrest is whether the crime about to be committed, or the crime being committed, or the crime that had just been committed is within the perception of the officer making the arrest. If so, then that is regarded in jurisprudence as a search made because of the commission of the crime in the presence of the officer making the arrest and making eventual search. Ordinarily, we say the search is made incident to a lawful arrest when the arrest preceded the search. If the search was done ahead of the arrest, the search would be based on suspicion, and therefore that is a warrantless arrest that is not valid under the contemplation of Section 5 of Rule 113, because the commission of the crime has not yet been known and the search was already made. But you should take exception to the fact that here the contraband is per se illegal. And so the High Court noted that one in possession of dangerous drug is in a continuing state of committing a crime, because the mere possession will subject him to arrest and prosecution. Unlike a firearm, which would only bring about a violation of law if without a license or a permit to carry, dangerous drugs is not of such category. Possession of the dangerous drug, as long as this is in the person of the possessor, renders the possessor criminally liable, unless he is authorized to possess the same. So the moment there is no authority to possess, he is not a user where the use of the dangerous drug is prescribed for his illness. The mere possession of the drug is already a crime. And wherever the possessor goes, he is actually committing a crime. And therefore, any search made would merely be a verification of the probable cause brought to the attention of the arresting officer. The question of whether the arrest was made and the seizure or search was incidental to the local arrest was also raised in a case where an elderly man entered a school campus without being checked by the security guard of the school. He simply entered the campus, and when the security guard noticed him that he did not pass through the routinary check, security guard tried to approach him, and this man walked hurriedly, indicating that he is doing something wrong. So the security guard kept up his pace and walking after this old man, and after he was overtaken, security guard inspected what was inside the body bag, and it was found out to be dried marijuana leaves also, obviously being peddled to the high school students of that school. So this man was then arrested and brought to the police headquarters, where he was booked and eventually charged for illegal possession of dangerous drug. Now here also, the validity of the search, which was without a warrant, and the seizure of the contraband was assailed because the arrest was made after the security guard already found out that the brief bag carried by this old man contains dangerous drugs, and only then was the arrest be justified after the search and the seizure was made. So it was argued that it is the arrest that was made incident to the seizure of the dangerous drug, and not the other way around. Now again, the Supreme Court reiterated the premise that since the mere possession of dangerous drug is already punishable, one possessing this can be arrested anytime, even without a warrant of arrest, because he is in a continuing commission of a crime. Wherever he may go, wherever he may be seen, he could be arrested because he is committing a crime. So although the search may have physically occurred ahead of the arrest, the search was simply a verification of whether indeed a crime was committed. But actually, there is already an ongoing crime being committed, because the mere possession of the dangerous drug renders the possessor already liable for arrest. There is already probable cause to bring about his arrest. Any search or seizure made is simply a verification of whether indeed the contraband possessed is dangerous drug. But that does not mean that the search was made even before the arrest was made. The arrest can be carried out because the offender is said to be committing a crime in flagrante, and therefore any time he could be arrested. Although the search physically was made before the announced arrest of the offender, the fact is the offender was already committing a crime when the search was made. So the search was done by way of verifying the crime being committed. So this is how you will understand the first situation where a warrantless arrest is valid. On the other hand, you may have read this case where a telephone call was received in the Western Police District headquarters along UN Avenue, that there were two persons who were lurking around the vicinity in the San Nicolas, Tondo, and appeared to be about to commit a crime. So the precinct commander formed a team of plainclothes detectives, sent them to that vicinity of the Del Pan Bridge. Also, a mobile patrol car with uniformed policemen was dispatched to the place. The plainclothes detectives positioned themselves at the end of the Del Pan Bridge, headed towards the North Harbor. The patrol car passed through the side street of this bridge, and at a distance already saw two persons standing near the foot of the Del Pan Bridge, looking left and right, left and right. This movement of the two invited the suspicion of the policemen on board the mobile patrol car. So they tried to approach the site where the two persons were standing. And when these two persons noticed that the police patrol car was headed to their side, they walked out of that place, and they noticed that the police patrol car was still following them. So they hurried up in their walking. The police patrol car also speeded a little. So they started running. Police patrol car then drove after them. They ran to the other side of the Pan Bridge, where unknown to them, there are already posted plainclothes detectives. So they were then arrested. The policemen on board the police patrol car justified their taking into custody the two persons, even without a warrant, on the basis of the conduct shown by the two persons. At the first time, the policemen caught sight of them while they were standing near the foot of the Delpan Bridge, that they were looking left and right, as if they were apprehensive of any law enforcer coming to their place. And when they spotted this police patrol car, they left the place, walked hurriedly. And as the police car accelerated its movement, these two started walking hurriedly, and then they ran. All the while that they were running, one of the two was holding his waistline while he was looking behind to see whether the police patrol car was still following them. Finally, they were cornered. A search was made on their person, and the one holding his waistline turned out to be possessing a 45 caliber pistol tucked in his waistline. So he was holding this to prevent it from falling while he was running. Policemen brought them inside the patrol car to the Western Police District, headquarters here at UN Avenue, turned them over there. And with their turnover to the desk sergeant, the apprehending policeman also surrendered the 45 caliber pistol that was seized from them. So happened at the same time, there were persons there reporting a robbery committed on their house. And when this man saw the 45 caliber pistol being turned over, he immediately said, "That is mine. So you were the ones who robbed our house." These two who were being collared by the policemen and who were handcuffed. On that basis, the two were booked. One was charged for illegal possession of firearm. The other one was charged for illegal possession of bladed weapon because he was carrying a knife in his pocket. That is why also while he was running, his right hand was inside his pocket while he was running. The two were convicted over their vehement objection against the admissibility of the firearm and the bladed weapon against them. They eventually appealed to the Supreme Court, and the issue is whether the seizure of the firearm without a warrant of arrest is valid. Over the argument made by the Solicitor General, Supreme Court ruled the seizure is illegal because there is none appearing in the record that may constitute probable cause for the making of the search. The report of the policeman that when they approached the two accused, their suspicion was already invited because they were looking left and right. Supreme Court asked, when is looking left and right? So the government lawyers argued that their conduct is confirmed by the fact that they were found possessing unlicensed firearm, also illegal bladed weapon. And this is borne by the conduct of the accused holding his waistline all the while to prevent the firearm from falling down while he was traveling fast. Supreme Court said this conduct of holding one's waistline while running, looking left and right, is not incriminating. This is the same conduct of a person suffering from a bump stomach, looking for a place to discharge. So it is not really incriminating just because a man is running, looking left and right, holding his waistline. Supreme Court said, we will be saying goodbye to our civil liberties and freedom if conduct like this would justify an arrest and a search. Every citizen would therefore be at the risk of being searched and on that basis being placed under arrest. From this ruling, it appears that there must be, even before the arrest and the search was made, circumstances that would convince an unbiased mind that a crime is being committed. But in this case, the policeman developed the suspicion on the act which is not really criminal. In other words, they gave meaning to an act which is innocent. And so, looking left and right to them demonstrates a behavior of having committed a wrong and trying to see whether there are law enforcers around to arrest them. The case for illegal possession of firearm was dismissed because the firearm was said to be illegally seized. This case demonstrates a situation where the act as it is innocent. It is the law enforcers that gave meaning to the innocent act in order to justify their act of arresting this person. And this is dangerous because any citizen may be the object of suspicion and on that basis may simply be arrested even without a warrant of arrest. This would guide you more or less in assessing whether the arrest without a warrant is lawful and valid, and along with the search made that may yield incriminating evidence. Along this, you have what was referred to in one bar exam as the Terry search rule, where a policeman walking along Rizal Avenue extension within the boundary of Caloocan City met at a distance a man who was walking as if he was intoxicated. The law enforcer is an anti-narcotic agent for some time, and therefore experience by training and by his education on the matter, whether a person is under the influence of dangerous drug. When they came face to face, this fellow looked at the policeman who was then wearing a jacket. So his uniform was not immediately visible. And the policeman noticed that this fellow had bloody eyes, red eyes, indicative that he had been using dangerous drugs and had been under the influence thereof. So he was walking in a way where he is said to be high on drugs. So the policeman stopped him. Thereupon he was frisked. And indeed he was found with tinfoil containing some tablets, which turned out to be dangerous drugs. The seizure was assailed as illegal because there is no basis to search the body of the offender. But then the Supreme Court justifies the prosecution of this fellow under this said Stop-and-Frisk Rule, which is identical to the ruling of the U.S. Supreme Court in that case of Terry versus the state of Illinois. So what is called in the United States as the Terry search rule is the equivalent of what we call here as Stop-and-Frisk Rule. But this can only be availed of by law enforcers who, by their education and training, are experienced to detect whether a person who may be stopped and checked is committing a crime or had just committed a crime or about to commit a crime. A simple law enforcer cannot invoke this because he is merely acting on suspicion. So the predicate of this, as explained by the Supreme Court, that renders the search valid is the experience and training of the law enforcer to detect whether a person has already committed a crime or is involved in a crime. So if the law enforcer is a rookie or one who has had no experience in handling narcotics, he cannot invoke the Stop-and-Frisk Rule. This is validated by the fact that the law enforcer who will simply stop a citizen in order to frisk him is one who is experienced in the training and knowledge that the conduct of a person demonstrates his involvement in a crime that may warrant a search bodily to determine any concealed weapon. The Stop-and-Frisk Rule is validated on this premise that law enforcers, out of protection for themselves and the citizens who may be around them, may stop any citizen whom, by their training and experience, they sense has committed a crime or is about to commit a crime. The search, however, does not include looking into the pocket. The search is only a bodily search on the outside clothing of the person being searched, because the purpose of this is simply to find out whether the person by whose conduct disclosed had been committing a crime is armed or not. The purpose of frisking is to find out whether he has concealed deadly weapon for the protection of the law enforcer and the people who may be around him at the time. So this is part of the check that law enforcers are authorized to carry on even without a warrant of arrest or a search warrant. The probable cause arises from the fact that the law enforcer engaged in this is well trained, well educated on detecting the particular violation being committed by the person who was stopped and checked. The Supreme Court even said that the basis of this is not the existence of probable cause, but the learning, training, and experience of the law enforcers to sense whether a person who would be stopped and frisked has committed a crime or is about to commit a crime or actually committing a crime. Now in this case also dangerous drugs were found in the person of the offender, and that, as I said, has been viewed as a continuing commission of a crime because the possession of dangerous drugs is itself a crime. So as long as the possessor has in his person drugs which are classified as dangerous drugs, he is actually committing a crime, and therefore the arrest is made in flagrante while the person arrested is committing a crime, and any search made on his person may be classified as justified under the Stop-and-Frisk Rule. But this rule does not include digging into the pockets or the inside clothing of the offender. This is only a search on the outside clothing of the offender in order to find out whether he possesses some deadly weapon that may endanger the life of the law enforcer and the citizens who may be around him at the time of the search. So you get this as the contemplation of the first situation where an arrest without a warrant is nevertheless valid. Second situation where the arrest without a warrant is nevertheless valid is where probable cause exists because a crime has been committed and probable cause exists out of facts and circumstances within the personal knowledge of the officer making the arrest. For this, the officer making the arrest must have personal knowledge that a crime has been committed. So if the commission of the crime was only reported to him, the arrest that he may make without a warrant would be illegal because it is made only on mere suspicion, because he himself is not knowledgeable on whether indeed a crime has been committed or not. So the predicate of the second situation is that there is a crime committed, the officer making the arrest has personal knowledge of that crime that was committed, and he has probable cause by way of facts and circumstances that would point to the person being arrested as the one who committed the crime. So it is not alone the fact that a crime has been committed. There must be facts and circumstances that would bring about probable cause that the person to be arrested is the one who committed the crime. So if, for instance, a person was stabbed, he was lying on the sidewalk, bloody, and there was a man running with blood on his clothes also. Although it turned out that this fellow is walking in the market slaughtering pig. So the blood on his clothes were the blood of the pig that he was slaughtering. The arrest of this man is still based on probable cause. But it turned out that the analysis would yield that it is not human blood, but the blood of pigs, because he's walking in the market slaughtering pigs. Then he will be released. But he cannot be charged for illegal arrest, because the arrest is based on probable cause. And he had witnessed the crime. He has personal knowledge of the crime because he saw the man who had been stabbed. This is the contemplation of the second situation, where an arrest without a warrant is nevertheless valid. Third situation does not apply to you, because this contemplates of a situation where the person being arrested is an escapee from jail or an escapee from a place of confinement. The officers to apprehend him are justified not to go to court and apply for a search warrant or a warrant of arrest rather, because that would involve time. And this is an arrest within the contemplation of hot pursuit, where the person to be arrested had been previously legally held, but he escaped. To rearrest him, bring him back to the place of confinement, does not require a warrant for his arrest anymore, because the arrest made on him after he escaped is an arrest made in hot pursuit. So this does not apply to you, because this does not involve commission of a crime, but simply escaping from the place of confinement. Not necessarily a convict, but even only a detention prisoner. Now, bear in mind that the arrest without a warrant, prima facie, is illegal. So the burden is upon the arresting officer to show the legality of the arrest. And this acquires significance if, in the course of the arrest, the officer making the arrest confiscated from the person arrested certain matters or materials which are evidence of the commission of the crime. Now, if the arrest was not validly made, the search and seizure of incriminatory evidence also are not admissible in evidence. They are what you know has been referred to as fruit of a poison tree. The government agent should be the first one to respect the law. So any illegally gotten evidence cannot be used by them to bring about the prosecution of an accused. It has to be evidence procured out of legal and legitimate means. So although a crime was really committed, the evidence of that crime may not be admissible because of the manner it was obtained. And if there is no evidence, the crime may not be prosecuted. So your analysis at this stage of whether the arrest was valid, whether the arrest is legal, goes far enough to affect also whatever incriminating matters were seized from the person arrested, whether it is admissible in evidence or not. At this stage, well, the offender was apprehended. You know of a law, 7438, that imposes upon the arresting officers the duty to then and there inform the person arrested of his constitutional rights. Primarily, his right to remain silent, his right to be assisted by counsel, preferably of his choice. If the person arrested has not been informed of this, any statement received from him after he was already under arrest is inadmissible because this was obtained when the subject is already under custodial hold of the law enforcers. Now here, Supreme Court had the occasion to differentiate a situation where an offender made statements voluntarily to an arresting officer or an officer responding to the commission of the crime, even without any question being asked. For instance, the neighborhood called on the police headquarters to immediately respond to their neighborhood because husband and wife were quarreling and they are killing each other. So a police patrol car proceeded to the site. A newspaper reporter tag along went to the site. Upon reaching the place, which is a place of squatters, a policeman had to put on the light to find out which shanty is the scene of the crime. A man holding a bolo, blooded bolo, came out and handing the bolo to the policeman. The policeman immediately drew his service firearm because the bolo is long enough to reach him if the fellow who is holding this would suddenly hack him. So he told this fellow to stay at a distance. And this man voluntarily stated, I killed her because he had an affair with my compadre. At this point, there was no question asked. It is the offender who made the statement in the nature of a confession, or at least an admission. The same was testified to in court over the objection of the defense counsel. Because while this is admitted into the record, then there is already that admission made by the accused that he was the killer. And this is corroborated by the bolo. All in all, you have the so-called Corpus Delicti. So the defense counsel vehemently objected to this. When the case reached the Supreme Court clarified that these statements made, which may be incriminatory to the person prosecuted later on, is admissible in evidence because these are statements spontaneously made which are not really made under custodial investigation. What the fundamental law prohibits and renders as inadmissible in evidence are those admissions or confessions made by way of answers to questions asked during custodial interrogations. So where the disclosure was made even before a question was asked, this does not come within that class of statements which are not admissible in evidence because it is not the statement protected by the Constitution. What is protected in the Constitution are those statements which would be self-incriminating in answer to the investigation done by the law enforcers after having taken the offender under their custody. The law suspects that the law enforcement may have resorted to some foul means to make the suspect admit or confess to the commission of the crime. That is why any such statement made when the declarant is already under custody is regarded as inadmissible unless the declarant is assisted by counsel, because the law regards that any such declaration must have been made under influence by the law enforcer. And for that matter, this is regarded as inadmissible. Another collateral matter raised here is that this statement was done without the benefit of counsel and therefore not admissible in evidence because the declarant was not advised beforehand that it is his constitutional right to be assisted by counsel. all these rights have been construed by the High Court to be respected as rights of the citizens under the fundamental law when the citizen is being investigated for the commission of a crime. The implication is that the person making such declaration, which is self-incriminating, is already under the hold of the law enforcers, while the law enforcers occupy a position of ascendancy whose control of the suspect may be coercive, and this is not reflected in what has been recorded. Relative to this right to counsel, even under the 1973 Constitution, the Constitution during the martial rule, a provision on this has already been made in the Constitution, that any admission or confession regarding the commission of the crime is not admissible in evidence if obtained without the assistance of counsel. The same was brought about by the militants during the martial law era, assisted by seasoned lawyers identified as civil libertarians. They all support civil liberty. And they made reference to the so-called Escobedo Rule, also known in some textbooks as Escobedo Doctrine. This rule or doctrine specifically refers to the right of an offender to be assisted by counsel. In that case of Escobedo, the offender was arrested for manslaughter. This was in the United States. He was taken to the police precinct, and while there, he asked permission of the police officer in command of the prison to allow him to use the telephone because he wanted to call his lawyer. The police officer denied his request and told him there is no need for a lawyer at this stage because the purpose is only to investigate whether he has a participation in the crime committed. The police officer informed him that the right to counsel begins only when a criminal case is already filed in court. Now here, in the police present, they are only investigating whether a crime has been committed or not. So the police officer denied the request to be assisted by counsel. Escobedo, however, tried to invoke his right to make one telephone call as to whoever he want to call under their laws there. A person arrested for the commission of a crime is entitled to one telephone call. may call his family or call any a lawyer or any of his friends about his present apprehension. This was denied. So he was interrogated, and eventually the statements given by him in answer to the interrogation focuses on him as a suspect in the commission of the crime, because his answers are taken and assessed to imply that he has some knowledge about the commission of the crime. Eventually, he was prosecuted for manslaughter together with some John Does whose identity has not yet been established. He was convicted. He appealed to the Federal Supreme Court of the United States. In that appeal, the U.S. Supreme Court made a distinction as to the nature of the questioning or interrogation conducted. And the High Court there said, if the person under investigation is only being asked questions to shed light on the crime committed, the nature of the interrogation is only investigatory. The right to counsel does not attach. But if the person under interrogation is focused upon as a suspect in the commission of the crime, the nature of that investigation would already be accusatory, and therefore person being interrogated has a right to be assisted by counsel. Otherwise, anything said by him cannot be used against him, because this would violate the provision of the Constitution against self-incrimination. Further, the U.S. Supreme Court said, at the beginning of the interrogation, the person being asked may have been invited only to shed light on the crime committed. But from the flow of the questions asked of him, the questioning may be developing into an accusatory interrogation, because the questions are focuses on the declarant as having some knowledge or involvement in the crime committed. When this point is reached in the interrogation, the Escobedo case said the police officer conducting the investigation must stop and then and there inform the person under investigation that he has a constitutional right to remain silent and so forth. Otherwise, further statements where he is being focused upon as a suspect already, taken without the assistance of counsel, violate his right against self-incrimination. Therefore, it cannot be used as evidence against him. In a case decided by the Supreme Court not so long ago, reference has been made to the same criteria as to the nature of the questioning, whether merely investigatory or already accusatory. And the Supreme Court made reference here to the practice of law enforcers requiring one whom they suspect may have knowledge of the commission of a crime to join a police line-up. And there are persons on the other side of a one-way glass viewing these persons who are made to join a police line-up. Some of those in the line-up are policemen, some are simply outsiders. The fellow who eventually was accused of the commission of a crime because the persons on the other side of the glass pointed to him as at the scene of the crime. At that time, they saw him there. So he was taken out of the line-up and he was then confined. The point that he asked the policeman before he was made to join the line-up that he be allowed to call his counsel was considered by the Supreme Court as not existing, because at that point in time the nature of a police line-up is not accusatory but merely investigatory, and therefore the right to counsel does not apply there. Precisely the only purpose of making the fellow join the police line-up is to determine whether he was at the scene of the crime or not. If nobody pointed to him, then there is no need to ask him any further question. And this is also true to a case where the suspect was made to undergo a paraffin test, whether he fired a gun or not. Now the High Court considered this as merely part of the investigation and not really focuses on the particular person whose paraffin test is being taken as the culprit. But strictly you will understand that this paraffin test is irrelevant if there is no firearm used in the commission of the crime. So subjecting a person to paraffin test to find out whether he has fired a firearm or not is relevant to the matter of whether he is a possible suspect or not. Not all suspects who are taken into custody are subjected to paraffin tests. They are only subjected to such tests if in the crime under investigation a firearm was used or a firearm was fired. So there is a relevant connection between the paraffin test and the crime committed, where a firearm was used. But the Supreme Court said the right to counsel does not apply here because the test is not accusatory. It is only a verification of whether the person subject of the paraffin test has fired a gun or not. Although, as I said, if you look at it deeply, you will say it hints that the one subjected to a paraffin test is a suspect in the commission of a crime because the crime was committed with the use of a firearm. Without the firearm, paraffin test would be illegal or immaterial. But you see that this is the thrust of the Escobedo rule. This rule is not found in our Constitution in 1973. What was engrafted in that martial law constitution was the Miranda warnings, the Miranda Doctrine. This case of Miranda followed the case of Escobedo. In this case of Miranda, the accused also was arrested for a killing. He was brought to the police prison in the state of Arizona. And there he was simply interrogated, was questioned, answers taken down, and after the evaluation of the answers given, the police officers concluded that he knows something about the commission of a crime. So he was then prosecuted for manslaughter. And the trial court found him guilty. He appealed to the state court of appeals. The finding of guilt was affirmed. So he raised this to the Supreme Court. The Attorney General of the United States argued that this Escobedo ruling is not applicable to Miranda because in Escobedo, the accused requested to be allowed to call a lawyer. Now here, Miranda did not do the same. And so that right to be assisted by counsel, if ever it is due to Miranda, has been waived by him because he did not invoke it before he made the statement. The lawyer who defended Miranda in this argument before the Federal Supreme Court pointed out that to speak of a waiver necessarily implies that the person making the waiver has knowledge that he has that right. While in the first place, the person has no knowledge that he has that right. He cannot be said to have waived it because in the first place, he does not even know that he has that right to be assisted by counsel. U.S. Supreme Court agreed with the logical meaning of this argument, that how could a person be considered to have made a waiver when he does not even know that he has that right, which purportedly was being waived by him. And so the U.S. Supreme Court required every arresting officer forthwith to read to the person arrested at that point these constitutional requirements. That is why this is called warnings, Miranda warnings. Because in this case of Miranda, the U.S. Supreme Court required all law enforcers making an arrest to inform the accused or to inform the offender, firstly, that he has a right to remain silent. Secondly, that any statement he may give may be used as evidence against him before any court of law. Thirdly, that he must be informed that he has a right to counsel, and if he cannot afford to engage the services of a lawyer, he must be informed that the government will give him one. All of these were required to be read to a person who is being taken into custody for the commission of a crime. So if you have seen these earlier movies at the time when the case of Miranda versus the state of Arizona was decided, you may have observed from the movie that when the law enforcer take a suspect, they pulled out a card from their breast pocket of their coat and read this to the person they are taken to custody. This is shown in that picture, Dirty Harry. They immediately get the card and you have the right to remain silent. And the statement you may give may be taken against you in any court of law. You have the right to be assisted by counsel. And if you cannot afford to engage service counsel, the government will give you one. This became known as the Miranda warnings. Any statement that would incriminate the declarant without prior Miranda warnings is inadmissible in evidence. It is regarded as a violation of the right against self-incrimination. This has been now incorporated in the 1987 Constitution. But the provision of our Constitution on this, under Article 3 now, went further to require that the assistance of counsel may be waived, provided that the waiver is made with the assistance of counsel. So the counsel is being dispensed with, but that act of dispensing will not be admissible unless done also with the assistance of that counsel. This seems to be illogical. So in this interrogation conducted by law enforcers now, you will see at the beginning of the sinumpaang salaysay, there are questions there are preliminary statements. Now you are being informed of your constitutional rights. After having been informed of your constitutional rights, are you invoking this? Then answer, hindi po. Handa ka bang magbigay ng malayang salaysay? Opo. Supreme Court called this as a monologue statement, and this is not considered valid. This came about because an offender was taken into custody, and to comply with this requirement of the fundamental law, in the preliminary questions reflected in the sinumpaang salaysay, these questions are asked. And the declarant who was taken to custody waived this. The trial showed the lawyer then tried to impugn this sinumpaang salaysay, but the prosecutor argued that the same is presumed to be valid. The burden is upon the accused or the defendant to prove otherwise. So this statement may be allowed. But then, on review by the Supreme Court, it was noted as disclosed during the testimony of the defense witnesses that the declarant has 3 brothers who are lawyers. So it is unbelievable that he will waive the assistance of a lawyer when he has brothers in the family who are lawyers. So the High Court considered this kind of supposed informing the declarant of his constitutional right is not acceptable. In fact, in one of such examination where the police officer who interrogated and took down these statements was asked, what are the constitutional rights of the accused? He cannot say. So, how could you have informed him of his constitutional rights when you do not even know what they are? So it becomes merely routinary. They just type it there. Then the answer also, opo, hindi na po. Then they require you sign. So now the Supreme Court became wiser and required that it must be attested by a lawyer. The waiver must be made in the presence of the lawyer and with the assistance of a lawyer. In a case where the statement was brought before the municipal judge for the judge to administer the oath, there was no witness to this statement. So the municipal judge said, I cannot sign that because there is no witness who is a lawyer to the taking of that statement. There was a court employee who studied law but has not yet passed the bar. So the judge called him, you witness this. Supreme Court berated the judge. Assistance of a counsel means a full-fledged lawyer, not just a student of law who has not yet passed the bar. So the judge was reprimanded. He should know better. When the law says lawyer, he must be a member of the bar, but not one who is only a graduate of law who has not even passed the bar yet. So the statement attested to and purportedly sworn to before the judge was considered inadmissible in evidence. So at this stage where the offender is arrested, there are already rules of criminal procedure that had to be observed. The rules of procedure do not begin only in court. Most of the procedure that brings about controversies are those made out of court. Because in court, there is the participation of the judge. And so the records of the case, whether true or not, deserves the credibility which the judge may have relied upon. But outside of court, non-judicial officers are the ones involved. And there is always a suspicion that they have coerced the person arrested or conveniently making him confess to a crime which he may not have committed. This is a fact borne out in some instances where there are poor guys who admit having committed a crime, but when they are brought to court to attest their admission, they deny. They all claim they were subjected to torture, and so they signed it against their will. Now, after the offender was apprehended, compliance with the said Republica 7834 comes in. The right of the suspect to be accorded these constitutional rights guaranteed to him. Any incriminatory evidence that may have been obtained at this course must be obtained also without a warrant. Again, the regular or the ordinary premise is that all seizures made without a search warrant are invalid because these are deemed to be an invasion of the right to the privacy of one's papers and effects and of his home, which is guaranteed under the Constitution. The only way that this could be had is when the court issues the warrant. But there are exceptions to this. So you have to know the exceptions where arrest is valid even though made without a warrant. Correspondingly, seizures of incriminating evidence is valid even though made without a warrant. These are exceptionals. And as I have forewarned you before, in your review, do not overlook the exceptions. Most of the questions asked or problems given in the bar are on the exceptions, not on the general rule that is known logically to everyone. After this offender had been taken into custody, the attitude now of law enforcers is not to investigate anymore, because even if they legally took the statement of the suspect, when this is utilized by the prosecutor in court, the police officer who took this down will be suffering the brunt of explaining how the questions were obtained. And they are the ones who are put on the witness stand and they are roasted there. So they would rather not involve themselves. They allow this to go on without any investigation. After all, they will be looking for a lawyer to be present during the intervention. So they simply would report they could not find a lawyer who is willing to assist the suspect. That is why the Supreme Court passed a resolution making it mandatory for all lawyers to render 60 hours of pre-legal service. So every lawyer becomes an ambulance chaser, looking for people who committed crimes but do not have lawyers. So they offer their service just to complete 60 hours. It's childish. After the accused or after the suspect was taken into custody, what will come next is under Rule 12 on preliminary investigation. If the crime committed carries with it the requirement of a preliminary investigation, because the penalty for the crime committed is no less than an imprisonment of 4 years, 2 months, and 1 day. Fiction correctional, medium period. The apprehending officer or detaining officer will require the arrested suspect that if he wanted the benefit of a preliminary investigation, which is accorded to him by law, he should sign a waiver of the provisions of Article 125 of the Revised Penal Code. You have this provision in Rule 112, now Section 6 of that rule. Rule 112 is on preliminary investigation. So this will follow as the second step in criminal procedure. If the crime imputed to the suspect carries a penalty of no less than 4 years, 2 months, and 1 day, but for the suspect to avail of a preliminary investigation, he should make a written waiver of the provisions of Article 125 of the Revised Penal Code. For otherwise, the arresting or detaining officer may not agree to have the case submitted to preliminary investigation because he may be made answerable for the crime of arbitrary detention if the period for confinement without the benefit of this waiver is exceeded. Under Article 125, you have there a period of 12 hours. If the penalty for the crime committed is a light penalty or its equivalent, a period of 18 hours if the penalty for the violation imputed to the offender is a correctional penalty or its equivalent, and a period of 36 hours if the penalty for the crime involved is afflictive or its equivalent. You have learned that during this period, the arresting or detaining officer can hold the arrested person who had been arrested without a warrant but on valid grounds, without any case yet being filed in court. But once these periods had been exceeded, the officer holding the suspect may be charged for arbitrary detention. So to escape liability from that, the rules protect the apprehending or detaining officer from possible accusation for arbitrary detention. So the rules provide for a waiver. And under the rule, the waiver must be in writing, made in the presence of a lawyer and with the assistance of a lawyer. Otherwise, no such waiver could be made. Now, when there is no such waiver, the apprehending officer may proceed with the filing of the case in court. But before doing so, Rule 112 under Section 6 requires the apprehending officer to bring the arrested person to an inquest prosecutor. The inquest prosecutor determines whether the evidence sufficiently establishes probable cause for detaining the person arrested. Otherwise, the inquest officer will require the arresting officer to release the arrested person, but to file a criminal complaint against him before the prosecutor's office, so that the determination of whether a case will be filed in court or not will depend on the findings of the investigating prosecutor. Should the arresting officer or detaining officer file the case in court without the benefit of a preliminary investigation when asked, the accused has a right to that investigation. The rules now allow him to file an application for a preliminary investigation in the court where the case is filed. But he must do this within 5 days only after he learned of the filing of the case against him. Supreme Court already ruled that the 5-day period is mandatory. So if the arrested person would like to have the benefit of a preliminary investigation, he should make a motion or application to this effect within 5 days after he learned that the case was already filed in court against him. The moment the 5-day period is exceeded, his right for a preliminary investigation is lost. So you will see that following the arrest of the suspect, what really would follow is a preliminary investigation if the penalty for the case involved calls for a preliminary investigation. If not, the case will be filed without the benefit of preliminary investigation, but only an inquest. An inquest is different from preliminary investigation. Purpose of an inquest is only to determine whether the evidence on hand is sufficient to show probable cause for detaining the arrested person. If not, the inquest prosecutor will direct the apprehending officer to release the arrested person without prejudice to the filing of a criminal complaint with the prosecutor's office so that further preliminary investigation could be conducted. If the offender was not apprehended, but he has been identified, either the law enforcers or the offended party may bring the case to the prosecutor's office, file a criminal complaint. The legal form for this is known as a complaint when it is filed only with the prosecutor's office for inquest or for preliminary investigation. If this would be filed with the court, which will assume jurisdiction to try the case, it is not the complaint that is filed with the court. It is an information. While the word information is used, it implies that the public officer filing this is a prosecutor, a public prosecutor. Public prosecutor does not file a complaint. What he files is an information. Non-public prosecutors who file this identical complaint are those law enforcers charged with enforcement of the law violated. They do not file informations. The offended party, they only file criminal complaints. The criminal complaint filed shall also be filed in court with the filing of the information if the case is one of those which cannot be prosecuted de officio. So you have the so-called private crimes, where under the revised penal code requires a complaint from the offended party. The public prosecutor alone filing an information in court would not suffice, because the primary determination of whether he or she would complain for the private offense or not is lodged with the offended party in the so-called private crimes. And that is why this is implemented by the rules of procedure, that without the complaint from that offended party, these so-called private crimes cannot just be prosecuted upon an information by the public prosecutor. During the preliminary investigation, this is always conducted for those crimes where the penalty is no less than 4 years, 2 months, and 1 day. So bear in mind that since courts of the first level, the Metropolitan Trial Court, the Municipal Trial Court, and the Municipal Circuit Trial Court have jurisdiction over crimes where the penalty is imprisonment of not higher than 6 years. You now have cases within the jurisdiction of courts of the first level and yet requiring preliminary investigation. This complicated the whole procedure. Before, it was simple. Only those cases within the jurisdiction of the Collegiate Trial Court, the court of first instance then, now the equivalent of regional trial courts and family courts. Preliminary investigation before was considered only to those accused of a crime within the jurisdiction of the regional trial court. So when the case is within the jurisdiction of Imperial Court, the accused has no right to a preliminary investigation. Now, when the rules of procedure was amended to include preliminary investigation over those offenses punishable by imprisonment of no less than 4 years, 2 months, and 1 day. This new rule became the subject of symposia among different organizations or chapters of the integrated bar. And I was called to speak on this. I pointed out the evil that may arise out of this lowering of the penalty for crimes where preliminary investigation is required. Because we have municipalities in remote areas in the Philippines where there is only one inferior court, a municipal trial court, or a municipal circuit trial court. So all violations within the municipality are brought before that court for the court to conduct preliminary investigation. And if the court finds that there is probable cause and there is prima facie case to hold the offender for trial, the resolution by the municipal trial judge or municipal circuit trial judge of the case is then forwarded to the provincial prosecutor's office. It is the provincial prosecutor who finally decides whether an information should be filed against the accused based on the resolution of the preliminary investigation. If the provincial prosecutor, therefore, upheld the resolution of the municipal judge in the preliminary investigation conducted by the latter, the provincial prosecutor's office will prepare an information, and that information will be filed with the court having jurisdiction over the crime involved. The result, if the crime involved has a penalty of no less than 4 years, 2 months, and 1 day, and therefore within the 6-year imprisonment within the jurisdiction of the Imperial Court, the case will be filed with the same Imperial Court. So the municipal judge who conducted the preliminary investigation will be the same judge who will try the case, because there is only one court in the municipality. The municipality is so poor to provide even a courthouse for the trial of cases. In some municipalities in Cotabato, the municipal courts hold session under a waiting shed of passengers, so along the highway, and they are there on certain days only. It will be in this municipality, then on this day. The judge goes to another municipality because there is no judge there on another day. So they have no permanent offices. The trials held under a waiting shed built along the highway for passengers to wait for passing passenger buses. So you could imagine how dusty it is. And the bench are only one big bamboo. The judge is there bringing his own chair. Otherwise, he should also sit on the bamboo. The dismal nature of our imperial courts in the provinces, more so in remote municipalities. So, the moment they lowered this penalty to include crimes within the jurisdiction of the imperial courts, in those municipalities where there is only one imperial court, preliminary investigation will be conducted by the same court, and if the case is filed for trial, the case will also be filed with the same court. You may have come upon this case of this judge in Pasig, the hanging judge in Pasig, who married the widow of the newspaper man Miharis. And the accused there cried foul, because every time his lawyer would raise an objection, even without any comment from the prosecutor, the judge immediately make a ruling, deny or overrule. And when the other party, the prosecution, will raise an objection, even before he's finished with his manifestation, the judge said, sustain. The accused is practically railroaded to jail. That is why originally judges of regional trial courts are authorized to conduct preliminary investigation if the case was filed with their son, without the benefit of preliminary investigation, and the accused moved to be given the benefit of a preliminary investigation. To save time, instead of referring the case to the prosecutor's office to conduct the preliminary investigation, the court then appoints the trial prosecutor to conduct the preliminary investigation under the authority of the judge. So after the trial prosecutor finds that there is prima facie case, the resolution is submitted to the court, so the court then calendar the case for trial. The judge has made up his mind. If the judge was the one who conducted the preliminary investigation, found the prima facie case, so how could you expect the judge to still uphold the innocence of the accused? So every move of the accused that may discount the finding of a prima facie case against him is being blocked by the judge. So this case was subject of a certiorari with the Supreme Court. Although the Supreme Court upheld that there is no rule against this, the Supreme Court thereafter admonished judges of the regional trial court not to conduct preliminary investigation of a case already filed with them for trial, because the suspicion that the accused cannot get justice is very strong, since the judge himself found already that there is prima facie case. For this reason, judges of regional trial courts were then disauthorized to conduct preliminary investigation. So, Supreme Court issued an administrative memorandum to this effect. That is why you learned previous to this that this regional trial courts cannot conduct preliminary investigations anymore. But before this case of Mijares, they conduct preliminary investigations. When the revision of the rules of criminal procedure lowered the penalty for cases to be subject of preliminary investigation, thus including cases within the jurisdiction of imperial courts, the evil brought about by this case was resurrected. So when I delivered this paper on this at the City Hall of Manila, they realized the evil, and so the Supreme Court again passed or adopted an administrative memorandum disqualifying judges of imperial courts from conducting preliminary investigation. The procedure became worse because there are municipalities where there are no municipal attorneys. The municipal attorney is the chief of police. So if the offended party was the victim of a crime in that municipality where the municipality is so poor, cannot afford a municipal attorney, offended party will have to travel to the capital of the province and file the criminal complaint with the provincial prosecutor's office. And the poor fellow may not have even the money to spend for his transportation expenses going to the capital of the province to file the case, then coming back. This is an evil that the Supreme Court should have considered, because now the reason why these leftists are multiplying is because the downtrodden people cannot receive justice from our institutions of justice. Our procedure has made it very expensive that poor people are practically denied the opportunity to get justice. So they resort to the vigilantes. They resort to these so-called kangaroo courts, where swift justice in criminal cases are administered without paying a filing fee. We cannot understand this, but this is happening, and so we have lost confidence on the sincerity of the High Court. Otherwise, this could have been easily corrected if really they have a conscience for the downtrodden people who are mostly the victim of injustice in this country. So now, municipal trial courts, municipal circuit trial courts, and these metropolitan trial courts are included. They cannot conduct preliminary investigations anymore. As far as metropolitan trial courts are included in this memorandum, this is nothing, because metropolitan trial courts are in metropolitan districts. And in every metropolitan district, there is always a prosecutor's office. You cannot find a metropolitan district where there is no prosecutor's office, where criminal complaints are filed. So in these areas where there are metropolitan trial courts, there is always a prosecutor's office where criminal complaints are filed. So they do not really affect the inhabitants in the metropolitan district. With this administrative memorandum, disauthorizing the metropolitan trial judge from conducting preliminary investigation, because they do not really conduct preliminary investigation. It is the prosecutor's office in the metropolitan district that conducts the preliminary investigation. Those in the municipalities are the ones who suffered by this amendment or revision, lowering the penalty for crimes subject of preliminary investigation. They should be reverted back to the original situation, where only crimes within the jurisdiction of the regional trial court and other collegiate courts is entitled to a preliminary investigation. Those crimes within the jurisdiction of inferior courts are easily disposed of because there is no preliminary investigation anymore. It is only a preliminary inquest on whether there is merit or not in the criminal complaint filed. So now justice is very slow. The rule that justice delayed is justice denied is now an institution. And even the Supreme Court is involved in that, because cases dragged in the Supreme Court cannot really act on cases with dispatch. Now, at this stage also, where the case is undergoing preliminary investigation, before, when criminal complaints could be filed with the municipal trial court or municipal circuit trial court, the court immediately issues a warrant of arrest to hold the accused under the jurisdiction of the court. That is why before, even on preliminary investigation, the respondent is already held under a warrant of arrest. So the parents of the respondent often inquire why there was no investigation and the son was simply arrested under the warrant of arrest. Well, because before, if the complaint is filed with a municipal trial court or the municipal circuit trial court, that court issues a warrant for the arrest of the respondent. So the time the respondent will know about his involvement in the crime is when he is arrested. Unlike where the criminal complaint is filed with the prosecutor's office, prosecutor has no authority to issue warrant of arrest, except in the city of Manila, where the Charter of Manila authorizes the city prosecutor of Manila to issue warrant of arrest. But even then, this is not practiced because there are courts here. So any application for a warrant of arrest should be done with court. But if you would look at the Charter of the City of Manila, this city prosecutor of Manila can issue warrant of arrest. Only it would be usurping this authority of the regular courts if it would issue warrant of arrest. So they do not issue warrant of arrest. Upon the filing of the case in court, the rules under Rule 110 will then operate as to who would be the complainant, what are the requirements to make the complaint sufficient. Most important under Rule 110 are the rules on duplicity of offenses, Section 13. The rule on amendments, Section 14. And the rule on where a criminal action should be instituted. The place where the criminal case should be filed is not a matter of venue in criminal cases. The place where the criminal action should be filed is jurisdictional in a criminal case. The action can only be filed under the rules of Section 15. Cannot be filed anywhere more so agreed upon by the parties. Although sometimes we refer to the place where the criminal case should be filed as venue, do not understand this in the same light as venue in civil cases. In criminal cases, the place where the crime should be prosecuted is not just a matter of venue, it's a matter of jurisdiction. So this is known in criminal actions as territorial jurisdiction over the crime, not venue. Venue is only in civil cases. We have exceeded 12 o'clock. Time for us to take our lunch. What time are we going to resume? What time are we scheduled to resume? 1 o'clock? 1 o'clock? Up to when? 5 o'clock. So we will resume at 1 o'clock. I have had no sleep yet. I left Naga 3 o'clock. And I came here directly from the airport. Because I understand we only have 2 days and a half to meet on this. So let us resume after lunch. Or let's make it 1:30. So we have time to eat also. So let us have our lunch break.